Code itself, because this relates to the
Please
procedure.
tell us, is it ultra vires, the constitution?
It's ultra virus.
Thank you.
I just have a question to you on this, on section 7. Now, section 7 really relates to what has been treated as the nitty-gritty of procedural law. I mean, this is really going, you say, in a civil court into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side.
Language.
The question therefore is this: the legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point which I said,
Sir,
that the functions of the
is
Supreme
it-
Court have been virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra virus.
इसमें ख्वाजा साहब,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at aspect of independence of judiciary, that is, freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of
Just note kar le.
the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
That will certainly answer your lordship. sir.
But please, one question also.
Since
noted.
we have just one
Raja sir.
section, can we just finish reading it?
Raja Sahab, if I may have a supplemental on
Yes,
what
ma'am.
my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
working
of
of
the
the
judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers?
Yeah,
Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and, for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That you say, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean,
My- with the-
where would
Sir,
that
एक
lead
second,
us?
if I sir,
With due respect
That is a
to
question
my lord.
ख्वाजा साहब, ये एक बात सुनिएगा, इधर एक
आप
क्वेश्चन
इसको खत्म तो कर लेना सेक्शन को आप सॉरी टू से
आर्टिकल 8 खत्म कर लूँ
आप पढ़ ही नहीं रहे
मैं
हैं।
पढ़ने का अभी पढ़ लेता हूँ सर। ये सवाल बड़े पर्टिनेंट
आप हर चीज आप नोट कर लेना।
नोट कर भी लिया मैंने सर। कर ये कहा मैं बता मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था आपने शायद इस्लाम और जो ये आप कह रहे हैं जो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है उसमें किसी और का दखल नहीं होना चाहिए। ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा।
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. No, when the law is totally ultra virus,
Sir, noted.
then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or not well, you do allow in review.
You are declaring
another
right
counsel.
of appeal ultra virus and right of review intra virus.
No, what I'm saying
Yes,
is
according to your own
that
arguments.
the question is that you cannot provide a right of appeal.
But you can
under
provide the right of
wait a
review.
minute, sir, under 184(3). If 184(3) right of appeal is given in accordance
आप
with
मेरे ख्याल में
the constitution, then